Please be seated. Oh, I see. I knew that was going to happen. Travis? Travis, I need you to switch the name, please.
I'd be happy to be Judge Bailey today. It'd be a big improvement for me.
Not mine. I'm good.
I wouldn't want the increased expectations, Judge Winthrop, if people thought I was you.
And are you ready to go, Travis?
All right.
Oh, we're already in. Good morning, everyone. This is the time set for oral argument in TX 20-0001, Pima County et al. Versus State. Council, welcome. We have read the briefs. We have conferenced this case this morning, and we were waiting to hear your argument. We have a lot of questions for you. I would remind counsel for the appellant that if you wish to have any time remaining or to do any rebuttal, that's on you. You just need to make sure that you monitor and police that. We are still social distancing, so we'd ask that you remain at council table to speak into the microphone so that everyone can hear you, and these proceedings are being recorded. With that, one last thing. When you start your presentation, if you would please announce your name and who you're representing, just for the record. And with that, counsel for appellant may begin.
May it please the court, Drew Ensign, Deputy Solicitor General for Appellants. I'd like to reserve 5 minutes for rebuttal. One thing in the act is plain. The legislature changed the characterization of desegregation expenses from primary to secondary. The tax court got this core issue right, holding that the act gave those expenses, quote, the statutory label of secondary taxes in the new ARS 15-10L. Moreover, plaintiffs themselves have explained that they, quote, used revenue from secondary property taxes rather than primary property taxes to fund, end quote, their desegregation expenses. And that's at page 115 of the appendix. The secondary nature of the taxes effectively resolves this case, since Section 972E only provides for reimbursement of primary property taxes. Plaintiffs therefore cannot look to Section 972E for the millions of dollars that they seek. The tax court reached a contrary conclusion for 3 reasons, none of which is tenable. First, it reasoned that the general definition of secondary taxes in Section 101(25) trumped the more specific provision of Section 910L that expressly addressed desegregation expenses. That is precisely backwards. Because Section 910L speaks to this issue specifically and is even more recent, that specific definition of 910L controls over the more general and older provision of 101(25). Second, the tax court thought that the act was unworkable, but the operation is actually fairly simple. The state no longer pays for the excess desegregation expenses that it used to. No one involved had the slightest apparent difficulty in calculating the new and old reimbursement amounts to the penny. So it was actually highly workable, and in fact, no one had any trouble making it work. Third, the tax court apparently thought the act was somehow unconstitutional, reasoning that the statutory label of secondary taxes in the new provision, ... cannot trump the constitutional limits on ad valorem taxes. But the act simply implements a budgetary decision not to fund an activity, which is a plainly constitutional exercise of the legislature's power of the purse. And even if you could construe the act to do something beyond that simple budgetary decision, you should simply, and that was somehow constitutionally problematic, you should simply sever that aspect and implement the budgetary decision which is plainly constitutional and also plainly what was intended.
Council, can I ask you just a couple of more basic questions?
Sure.
How many counties or how many school districts are under a desegregation order in Arizona?
Your Honor, that's not in the record, although I know for a fact there are several, and this is the only one that has brought suit. Others have seemingly managed to make this provision work without resorting to litigation.
And you would agree with me, wouldn't you, that in just more general terms, that the tax court at least got it right that there is a discrepancy between 910L and the more general section, and I think it's 25, correct?
Your Honor, there's certainly tension between those two provisions, but the canons of statutory construction are very clear as to how you resolve that tension by allowing the more specific, and in here also more recent provision to control over the more general and older provision.
Counsel, do you agree that the taxes imposed to pay for these desegregation expenses are to be included in the calculation of the 1% limitation?
We do, Your Honor. That certainly the legislature did not try to eliminate any constitutional restrictions on taxes. And so the 1% limitation stands undiminished by the act.
So the state's position is that it's the county, or more specifically the school district's obligation to figure out a way to fund that mandate.
That's correct, Your Honor. And in that respect, it's no different than essentially anyone who's ever confronted a budget, whether or not that's a family, a governmental entity, or a company, or frankly, anyone. Whenever your projected expenses are expected to exceed your projected income, you have two broadly speaking ways to address that. You can either lawfully increase your income, or you can lawfully decrease your expenses. And here that translates into two, fairly simple options. One, they could lawfully increase their income by submitting it as a levy override to their voters. And if so, that would completely fix this problem. Notably, they've called this act unworkable, but that is one highly workable, highly simple solution that simply wasn't tried. And there's no dispute that had they done so and received voter approval, it would have got them out of this supposedly inescapable box that the act puts them in. And second, they could find a way to reduce expenses, either the desegregation expenses or otherwise in the county budget. And, notably, one thing that was not even tried is they could have asked the federal district court if we spend the $55 million instead of $63 million, would that be sufficient to meet our obligations under this 4-decade-old desegregation order? And if the federal district court had said yes, that absolutely is another highly simple, highly workable solution that simply wasn't tried.
And counsel, what of the county's argument that they don't have, in your brief you say simply, look, go back to the other taxing entities and use your political will to have them cut budgets, because it's not necessarily that just the school district has to cut a budget, because as you pointed out, if the secondary taxes fall underneath the 1%, all of this is academic, because they still can tax up to the 1%, including secondary taxes, if that total amount is below the 1%. But Pima is saying in their briefing that we don't have a way to get out from under. How do we constitutionally change what our tax structure is from these other entities? How do we do that? We don't have any kind of statutory mandate with how we can adjust the fact that, if we're at 110 and our 1% cap is 100, what are we to do? And what's the state's answer to that?
Well, Your Honor, as an initial matter, there's the two solutions I just discussed, which were not even tried, which are they could have submitted it as a levy override to their voters, or they could have sought approval from the federal district court to simply spend less.
Well, but one of your suggestions was you can go back to your other taxing entities, basically, and adjust budgets before you assess the levies. Is there a way to do that?
Your Honor, not specifically, but it's inherent in the nature of the budgeting statutes. In Title 42, the provisions are quite complex, but at at a fundamental nature, let's say Pima County, for example, submitted a budget that suddenly proposed to double their expenditures, radically exceeding the revenue control limit and exceeding the allowable year-over-year increase. In that situation, what Pima County would do is simply say, look, your budget is unlawful. Go back to the drawing board and submit a budget that complies with the rule. And here, it's functionally very similar in that once Pima County has all the budgets, it knows for a fact that its budget is no longer compliant with state law. And not only is it not compliant with state law, it violates state law dollar for dollar directly attributable to these desegregation expenses. There's 100% overlap between the illegality of their overall budget and these particular expenses that used to be covered by the state but are no longer. So they would have no trouble in identifying exactly what the problem is that causes their budget to be unlawful. And instead of simply throwing up their hands and trying to implement an unlawful budget, they should tell Pima, the TUSD, their budget is unlawful and to go back and find a way to make a lawful one.
Of course, another option is for the legislature to fix its statutory inconsistency.
Certainly, this could have been drafted in a way that would be more straightforward, but the intent is overwhelmingly clear and the text is clear enough to be implemented. And, the legislature, two things about workability. First, for the first 5 years of this desegregation order, the state did not pick up the additional state aid for education or cover the excess. So it certainly was a workable circumstance for the first 5 years that Pima County simply budgeted for this and paid for it itself. So we have 5 years of experience that is in fact workable. But yes, the legislature probably could have been clearer, but they were pretty clear. And it notably is the case that every single legislator that looked at the text thought it did X. So did their own Pima County administrator. Even in their own briefs, they admit that it was billed as a secondary tax. And so the fact that everyone involved thought it was X, including the party themselves, suggests that when they come into court and tell you it actually unambiguously means Y, we can be reasonably skeptical of that. And the text itself confirms that. I mean, it's not just the 910L, it's also the 4 conforming changes that every single instance where they saw primary, they changed it to secondary, which leaves an overwhelming amount of intent that's readily ascertainable that the legislature tried to change this from primary to secondary. And even the tax court correctly gave it credit for having done so. And once it's changed to secondary, the text of 972E makes it very clear you can't get additional state aid for education for secondary. That's by its text limited to primary. And that's very clear on the face of the text. So this is somewhat a circuitous way of doing it, but the intent is quite clear, and that intent should be given effect. Moreover, I think the canon against surplusage has enormous power here. And really, the plaintiff's interpretation just gives the act almost no effect whatsoever. The tax court literally gave it no effect. The act does nothing except occupy space in, the ARS. But at least they tried. They say that it affects a disclosure requirement. 4 problems with that. First, it squarely violates context. This was a budgetary bill, and a budgetary bill that arose in the circumstance of the legislature's patience had run out with TUSD. But their interpretation gives it no budgetary effect whatsoever, making it completely anomalous, which leads into a second problem, which is that without any budgetary effect, it's constitutionally doubtful whether or not it can be in a budget bill. And so the canon against constitutional avoidance suggests that you should not allow that to be the case. Third, the legislative history is incredibly clear. There's not the slightest suggestion that anyone had on their mind disclosure rather than whether or not they're going to spend for this. So there's an error of unreality about their attempt to avoid surplusage. And fourth, even their interpretation only gives effect to the final sentence of Section 910L. It leaves the preceding 91 words completely superfluous as is. So it's only the most modest amount of not, avoiding surplusage, and in a way that is wholly implausible and perhaps unconstitutional and violates context. And if there's no further questions, I'll reserve time for rebuttal.
Any? No. All right, thank you, counsel. Counsel for the county?
Yes. May it please the court, my name is Ben Cooper and I represent the Tucson Unified School District Number 1. The problem with opposing counsel's argument is its premise is wrong. while it is true that Section 910L is about budgeting, this case is not, as the tax court realized in its well-reasoned decision. This case isn't about the state's payment of aid for desegregation or its reimbursing of desegregation expenses. Pima County and Tucson Unified School District brought this action because state failed to pay what it was obliged to pay under a different set of statutes, ones that deal with how to implement the 1% limit. The state argues, well, it was implied, that framework was impliedly altered by Section 910L, which by its terms deals with budgeting. And Mr. Ensign is busy talking about how this was illegal budgeting. But that's not what the issue in this case.
But Mr. Cooper, if we read the statutes the way you read them, it's really a nullity, isn't it? I mean, there's really nothing there. I mean, why would the legislature put that in there if the purpose wasn't, the specific purpose is to do exactly what the department is arguing here today?
Your Honor, it's not a nullity. It just doesn't affect this case. If the state wants to bring a lawsuit, a different lawsuit, not Pima County's and Tucson Unified School District, challenging how Tucson Unified District budgets and how it spends the money that it raises through its levies, it can do that. If the state wants to go into the district court or the Ninth Circuit in the desegregation action and explain that our spending is illegal and should not go forward, it can try to intervene, it can do whatever it wants. But that's not what this case is about, because this case is not about the state's reimbursement of desegregation expenses. The reason we are here today is because everyone's taxes, whether the counties or the Pima County Community College or Tucson or any of the other entities whose budgets are subject to this, all of their spending together rises above the 1% limit. It is completely arbitrary to assign Tucson Unified School District's desegregation funding as opposed to all its expenditures for desegregation, or its as
Well,
opposed.
you say it's arbitrary, but I say that's a policy
Yeah, is it
decision.
exactly, is it arbitrary or is it just a policy decision?
No, it's arbitrary to say that this payment that is owed is on account of desegregation spending or desegregation levies. Because the reason we are above the 1% level is because of everyone's spending put together.
Oh, wait a minute. If you put all the money in a pot, then the department says, okay, well, that's all the money in the pot, but guess what? This money is not primary. This is secondary. So it's a policy decision.
It may be a policy decision, but it's not the policy decision that the state made here, because the state legislature, because when the state makes that decision, it should have gone to 972E and changed the formula and the definitions in section 101, 20, and 25 to do it. This court said in the Pijanowski case that implied amendments are disfavored. Well, that's particularly true here.
Well,
Well, that's what- go ahead.
972 already says primary property taxes. So what would they need to do further in 972 to effectuate what they said the purpose was of this act?
Well, what they would have had to do was change the definitions and then square this with the constitutional mandate that this statutory implementation scheme, which is 972, has to be consistent under section 18.8 of the constitutional provision with those definitions.
You're not arguing the department's interpretation is unconstitutional, are you?
Well, we're saying that the statute is not unconstitutional. That is 910L, because the statute doesn't change the categories in section 972E as defined in section 101. What we're saying is that this would create a constitutional problem, because then the categories.
That's my question, is your position, just so I want to be clear, is your position that the way the department is saying this should be interpreted would be unconstitutional?
Yes, it runs afoul of.
What does it violate?
I'm sorry?
What does it violate?
What
constitutional provision does it violate?
The problem is that it takes the categories that are under 101, under the limit, and subject to this entire scheme, and takes them out and makes them non-compliant with the constitutional exceptions. Remember that the primary and secondary label is not one that the Constitution uses, so calling a tail a leg doesn't make it one. The
Okay,
Constitution,
But isn't the state conceding that both primary and secondary have to fall under the 1% constitutional limit? So if they're,
I don't understand that to be the statement, because the definition of secondary taxes is essentially squares with those
right,
provisions of the Constitution that are not under the 1% limit. They've been dodging this question of whether Tucson's desegregation levy falls under the 1% limit or not. Today, they've clearly admitted that it does. So the county, and the only reason the 1% limit is affected is because a portion of the total exceeds the 1% limit. But one could ascribe that to that excess to Tucson's general levy. One could ascribe it to the Pima County Community College
the
levy.
legislature said we're ascribing it, we're taking the deseg costs out. So if, assume that the state is agreeing that secondary and primary both fall under the 1% of Article 9, Section 18, then how is this unconstitutional? If that admission is where they are today, how is this unconstitutional?
The problem is, in order to get to that reading, and they have to basically impliedly amend Section 972E when the legislature didn't do that. Mr. Ensign was correct when he said the legislature could have been more straightforward. I believe it was his term.
Sure.
In fact, we should demand that the legislature be straightforward and amend the formula, not drop a reference in a statute having to do with the budgeting, which is what Mr. Ensign complains about, that this is illegal budgeting. That's not what the county and Tucson Unified School District are concerned about. They're not concerned about budgeting. That's for another case in possibly a different court. This is about how to implement the 1% limit. If once you decide that these levies are under the 1% limit, it sets in place a mechanism. They don't complain that the county gave credits. The state is just saying, well, we're not going to pay for those credits. But the statute doesn't give the state the authority to say, we're not going to pay those credits because we don't like the spending, or because we've somehow, in a different statute that deals with budgeting legalities, which is what Mr. Ensign keeps going back to, we think that some of these things are improperly budgeted. If they said, for example, that the county had illegally budgeted some of its expenses, so therefore we're not giving state aid to education because we don't like the way the county budgeted, they don't get to do that. It's not in the formula for implementation.
But, and last question, doesn't 972 already exclude any other secondary taxes that Pima County is levying against its taxpayers by using the phrase total primary property taxes? I mean, if Pima County is levying tens of millions of dollars in secondary taxes, those already have never been included in the payback requirements of 972. So
I'm not suggesting that they are. I'm saying you can't convert a quarrel with how an entity budgets, which is what 910L is about, and say that this is now going to be read to affect a mechanism that is really not about budgeting at all. It's about how to keep school districts from carrying the freight for everybody. You know, Mr. Ensign speculates that, well, the reason why no one else, other school districts have sued for desegregation funding is, well, maybe they've dealt with it better. I don't know what that speculation is. The reality could be that all of that funding didn't reach the 1% level, so no state aid, that is for the county and Pima and the community college and all the other districts, didn't reach the 1% level, so it was all covered. We are here today because the total did exceed the 1% limit, but that's a total for everyone. And if the state wants to change the way it implements the 1% level, the 1% limit, then it should do it. If it wants to,
Well, didn't they try to? I mean, it seems to me you're arguing that, well, the statutes don't allow them to do it. Well, it appears to me they had made a good faith attempt to do it.
Your Honor, I don't think, if that's what their intent was, it's not expressed as the tax court recognized in the statute. They did not amend the 1% formula. And if they'd wanted to do that, they could have gone back.
Is there anything in the historical record when they passed this that would indicate consistent with your position?
Your Honor, I think
It calls for yes or no.
I think we rely on the plain language of the statutes.
So is that a no?
I think there is, the
I'm
legislative
going to keep
history
going
is,
until you give me a yes or no. Is there anything in the legislative history that would support your position?
the legislative history does not support either party's position because the legislative history is silent about whether the legislature intended to change the mechanism for implementing the 1% limit. All they say is that the state didn't want
So,
to
Mr. Cooper, I'm
pay.
going to take it that that's a no.
I
There's
agree,
nothing
it
in
is a
the-
no for both sides, Your
Okay.
Honor. Because the comments they quote talk about people not wanting to pay for desegregation spending. As I said, this 910L is a budgetary limitation, but this is not about budgeting desegregation expenses. This is about compensating the school district because it's taking the hit for everyone's spending above the 1% limit. And if the legislature wanted to do that, to change that formula, then the legislature should have amended and had to amend that formula, not do it the sideways method that forces the state to argue, it's by implication. Because as this court said in Pijanowski, amendments by implication are highly disfavored, and they should be disfavored here as well. And the fact that the legislature hasn't gone back to try to change that since the tax court's ruling, I think, if they wanted to do it, they should have done it that way. And they should not have left this court to figure out, or the county or the school district to figure out how to implement a system that hadn't been expressly changed by the legislature. It's fair enough if they want to take on desegregation spending through budgetary limitations, but that's simply not what this case is about. The problem is that it really does compare apples to oranges. And this could have been dealt with any number of ways that would have made any kind of legislative intent clear in the terms of the statute. There could have been changes to the definitions of primary and secondary. There could have been cross-references. There could have been some kind of indication in the text of the statute that they were not just amending the budgetary provisions in 910L or 910, but that they were also changing the implementation of the 1% limit under 972E. And it's critical to understand this is not about desegregation spending. And it's not even about budgeting in this case. Pima and County and Tucson Unified School District framed the claims in this case. If the state had wanted to make a challenge to spending, to what happened to the money and whether it was spent on things the legislature didn't want, they should have filed counterclaims or brought their own action challenging what happened to the money. And if they think that the district court should not require us to spend the money, good luck with that. Tucson Unified School District has been trying to get relief from the district court's orders in that case for years and is currently on appeal trying to do that. But the conduct of the desegregation litigation simply was not at issue in this case. Suffice it to say that we disagree with the characterization of it, but it's also not at issue in 972E, which implements the 1% limit, because this really has nothing to do with what we spend the money on. It has to do with how you protect the taxpayers from having taxes in excess of the 1% limit. And what they're trying to do is say, well, in a separate statute, the legislature changed the name of something without changing the reality of it. That is, this is a tax that was not passed by a budget override and does not have to do with bonds. And we're somehow going to make it a secondary tax, even though it would take those implementing definitions out of consistency with the 1% limits definitions of what's not subject to it. It takes there's no recognition in any legislative history that the legislature was trying to make those categories no longer line up with what the 1% limit in the Constitution requires. And if the legislature is going to make that fundamental a change, then the legislature should do it explicitly by amending the correct provisions of the Act, not by putting in a budgetary limitation that still affects budgeting, but that has nothing to do with the 1% limit or what the county is supposed to do once it finds out that there's an excess and it has to credit taxpayers. This is just a backwards way of doing it, and the legislature, if it wants to achieve a lawful end, it should do it lawfully and should do it plainly, and not back into it by a provision that simply does not attempt to do, in plain language, what the state contends was the secret intent or of certain legislators to undermine spending on desegregation. Thank you, Your Honor. Any issue have further questions?
All right, thank you. Counsel, any final word?
Sure, Your Honors. 5 quick points. One, there was no need to amend 972E. It expressly on its face says that it will only pay reimbursement for primary taxes. And thus there's no need, since 910L makes them secondary, there's no need to amend 972E because 972E in no universe can give reimbursement for secondary taxes. That's plain on its face. Second, I heard opposing counsel that complain that this was completely arbitrary, that it's simply TUSD's budget, but that's not the case at all. The overage here is 100% caused by TUSD's spending in excess of a formula that the legislature's provided. It's not other things that cause this. It's specifically dollar for dollar what plaintiffs are here suing about that has caused their Pima County's budget to be illegal. And more fundamentally, it's not arbitrary. What happened here is that plaintiffs tried to spend the state general tax dollars without the legislature's consent and instead over their specific objection. Like all budgeting entities, I'm sure plaintiffs prefer to spend other people's money, but the legislature specifically cut them off, and that's what 910L does. That's not arbitrary. They may not like it as a policy choice, but it's not arbitrary or unworkable. It's actually quite clear on its face what it does. Third, I think the canon of reading statutes in pari materia is very important here. These are 2 different provisions of Title 15, both of which deal with school finance. They're clearly meant to be read together, and divorcing the 2 from each other makes no sense, particularly as once you understand the change from primary to secondary, 972E implements what the legislative intent was. Fourth, there's an air of unreality about the legislative history here, which really could not be clearer about their intent. There's no quote-unquote secret intent, I think they called it. It was unambiguously expressed both by the proponents and opponents of the act. Absolutely everyone understood what this was going to be, including Pima County's own administrator. This was not some secret intent. Here's what, from the text and the legislative history, their own administrator, Huckleberry, said. The act, quote, appears to have been an attempt to place the burden of desegregation taxes on residential property owners within the district to eliminate most of the additional state aid to education that has been paid by the state for almost 4 decades. And that's page 257 of the appendix. Their own administrator had zero difficulty understanding what the effect of the text and the legislative history was. And so this intent was the furthest thing from secret that you could imagine. And fifth, 972 is not needed to implement the 1% limitation. Notably, ARS 15-972E only deals with school finance. It can't implement the 1% limitation because it doesn't deal with anyone else's budget other than the school districts. What actually implements the 1% limitation are many provisions of Title 42. In particular, ARS 42-17-152A provides that you can't spend more than the 1% limitation. And that is what actually implements it and what would tell Pima County that once you add up everything and it's over the 1%, you can't do that. And so it's not 972E that's needed to implement the 1% limitation. It's actually all of Title 42. But even if it didn't, the 1% limitation is self-executing. Even if the legislature never repealed all statutes dealing with it, it still exists and would still exist as a limitation on what you can tax. It doesn't need implementing statutes. It is self-executing on its face. And if you tax in violation of it, that's illegal under Arizona law in the complete absence of any statute.
Good.
Thank you, Your Honors.
All right, thank you. The matter will be deemed submitted. We'll issue a decision in due course. We thank you for your arguments today. Court's in recess.